Hi, so this is Professor Moore, and I have succumbed to whatever it is that is making all of my civil procedure students cough and sneeze throughout the class. I now have it. So I doubt that I'm going to be coming in tomorrow. And we're getting so close to the end of the semester that I just thought I would record this video about what we were going to talk about, and we'll just continue to go on for Wednesday's class, and God willing, I'll be ready to come back on Wednesday. All right, well, let me start with the slide that I ended with the last class because it contained two illustrations of when we would use forum nonconvenience, and you didn't really know what that was when you saw this on Wednesday. So the idea here is that the federal court system is, of course, one unitary system with 94 different district courts, and cases are able to be transferred from one district to another within the federal system. However, each state court is its own closed system, and of course, foreign courts are their own system. So there can't be transfers of cases between states, or from federal to state, or from federal to foreign, or from state to foreign. So, in the case where the plaintiff files suit in the state court and the defendant thinks that the suit should actually be in another state court or in a foreign court, then the doctrine that would be followed would be the doctrine of forum nonconveniens. Similarly, if the plaintiff files suit in a federal court and the defendant thinks the suit would be better heard in a foreign court, that would be also a motion to dismiss for forum nonconveniens. Now, it's important to point out that we don't get to a forum nonconveniens motion unless everything about the plaintiff's chosen forum is correct. So, in other words, we're talking about a forum that the plaintiff has chosen where subject matter jurisdiction exists, personal jurisdiction exists, and venue exists. If one of those three things didn't exist, then the defendant could move to dismiss for lack of whatever. But forum nonconveniens assumes that the plaintiff has technically chosen a proper court. The idea is just, there's this other court in another system that's more convenient for this trial to be heard. Okay, so remember last time we were talking about, well, what's the big deal about, a transfer based on 28 USC 1404A versus a transfer based on 28 USC 1406A? Who cares? Well, the first thing that we said was that the plaintiff's choice of forum is given weight on a 1404A motion because the plaintiff, by definition, has chosen a forum that is correct. Correct personal jurisdiction, correct venue, correct subject matter jurisdiction. So, on a 1404A motion, the defendant bears the burden of showing that the balance of convenience weighs clearly in favor of a transfer of venue. The second thing that makes a difference between 1404 and 1406 is that the governing law in a diversity case may be different depending on the section that was used for the transfer. And this was illustrated in the Piper aircraft case, although it was in a footnote, and I don't think you've had enough background to really have caught that footnote. So I'm going to go into an explanation of that footnote. So let me get the footnote actually up here. So after reviewing certain cases under the Erie Doctrine dealing with choice of law, and of course we haven't done Erie yet, we're going to get to that next semester, but the basic premise of Erie Railroad versus Tompkins is that a federal district court sitting in diversity jurisdiction must apply the substantive law of the state. So state substantive law, federal procedural law. So there's a couple of Supreme Court cases that have dealt with the Erie Doctrine as it applies to choice of law rules. And after the Supreme Court cited those cases, it said that the district court concluded that California choice of law rules would apply to Piper and Pennsylvania choice of law rules would apply to Hartzell. It further concluded that California applied a governmental interest analysis in resolving choice of law problems, and that Pennsylvania employed a significant context analysis. The court used the governmental interest analysis to determine that Pennsylvania liability rules would apply to Piper, and the significant context analysis to determine that Scottish liability rules would apply to Hartzell. Okay, so you probably just didn't even read that at all, or if you did read it, you said, I have no idea what the court meant by that, and you just skipped over it. So I'm going to explain that now. Okay, so the first thing you have to understand is that there is a difference between choice of law principles and the actual substantive governing law of a state. So, of course, the United States has 50 states, the District of Columbia, Puerto Rico, and so frequently some transaction or some event will involve more than one state. It'll be an interstate type of event or even an international type of event. And so the question frequently arises, which state's law applies to this dispute? So I'm sure that by now in your other classes, you've seen that states don't always agree on the governing law in contracts or on a tort claim. And so how does a court proceed when one party is saying, well, the state of, or the law of state A should apply, and the other party is saying, no, the law of state B should apply? Well, every state has adopted, or maybe judicially developed, a set of principles called choice of law principles or conflict of law principles. And states, not surprisingly, follow various types of choice of law rules. By the way, choice of law is the subject of an entire 3-credit course in law school taught by Professor Menzel currently, and I would strongly recommend that you take it. So you can see that it's quite more complicated than what I'm making it here. But so, for example, the restatement of conflict of laws adopts basically a principle that the state with the most significant contacts to the dispute should be the law of that state should be the governing law. Older versions of choice of law rules tended to focus on the law of the place where the thing happened. So the law of the place where the accident occurred, the law of the place where the contract was executed. Those rules had the advantage of being very easy to apply. They had the disadvantage of not really being flexible enough to get around in cases where they didn't seem to make any sense. And as the court in Piper pointed out, there's also the governmental interests analysis that other states follow. So whatever the choice of law rules that this state has decided to adopt, that's the group of principles that the court will apply to decide which substantive law should I apply. So, for example, a court in Florida is always going to apply the Florida choice of law rules. A court in Illinois is always going to apply the Illinois choice of law rules. So that's an entirely separate group of rules from the actual governing law. In Piper, the governing law would be negligence, strict liability, or you might have the law of contracts, etc. So let me give you an example. So here is an illustration of choice of law principles in general. And we're going to have a hypo that's pretty much based off of Piper aircraft. So an airplane crash occurs in Scotland of a plane manufactured by Piper aircraft. The plaintiff, who is a Scottish relative of a deceased Scottish passenger on the plane, wants to choose whether to file suit for products liability against Piper in state court in California or state court in Pennsylvania, where Piper manufactured the plane. Assume that Piper is subject to personal jurisdiction in both California and Pennsylvania. So, this is less scary than it first looks. So, let's just go through this one line at a time. So, the first line is going to be the substantive tort rule, or how we also call this the governing law. So, California, and this is completely hypothetical, okay? It's probably not true at all. I'm just using this for purposes of analysis. So California follows the substantive tort rule that they do not allow products liability cases in the case of airplane manufacturers. Okay, so airplane manufacturers have gotten together as a very strong lobbying group, and they've lobbied the legislature in California that no products liability is allowed against airplane manufacturers. Pennsylvania, on the other hand, their substantive tort rule is that products liability is allowed in the case of airplane manufacturers and indeed everybody else. And Scotland, as we know, at least at the time, its substantive tort rule was that there was no cause of action for products liability at all. Okay, so that's the substantive tort rule. Obviously, if you're the plaintiff, you want Pennsylvania law to apply. So how do you get there? Now you look at the state's choice of law rules. So let's just hypothesize that California follows the old kind of rule that looked, to the place where the defendant manufactured the product. And it says, that's so the defendant here manufactured the plane in Pennsylvania, so Pennsylvania law is going to be the law that's going to apply to this dispute. Pennsylvania, on the other hand, follows the choice of law rule that the law of the place where the accident occurred is what is going to govern. And that, of course, would be Scotland. So the next line is, if we file in state court in California or state court in Pennsylvania, what choice of law rule would that court use? And quite simply, if we file in California state court, that court will use the California choice of law rule, which, as we said, is that the law of the place where the defendant manufactured the product is what's going to apply or govern. If you filed the case in Pennsylvania state court, then the court is going to apply the Pennsylvania choice of law rule. So the law of the place where the accident occurred is going to govern. Now, here's the part that's sort of skipping ahead to the Erie Doctrine. So a federal district court sitting in a state is going to apply the state's choice of law rule normally. So if the plaintiff, in other words, filed this case in federal district court in California, then the California court, federal court, would apply the California choice of law rule. And that's the Claxon case, which we'll get to next semester. Conversely, a federal district court in Pennsylvania would apply Pennsylvania's choice of law rule. So therefore, adding it all up, if the plaintiff were to file either in state court or in federal court in California, that court is going to apply Pennsylvania tort law. Why? Because California's choice of law rule is that the law of the place where the defendant manufactured the product governs, and Pennsylvania law is where Pennsylvania is where the defendant manufactured the plane, and Pennsylvania's substantive tort rule is that products liability is allowed. Weirdly, if the plaintiff were to file the lawsuit in Pennsylvania, either state court or federal court in Pennsylvania, then that court would end up applying Scottish tort law, where product liability is not allowed, because Pennsylvania's choice of law rule is that the law of the place where the accident occurred is what governs, and of course the accident occurred in Scotland. So counterintuitively, in this completely hypothetical example, in order for a plaintiff to get the governing law that it wants of Pennsylvania, it would need to file its lawsuit in California. Okay, so this is going to be taking the illustration one step further to show why it matters when you transfer a case between federal district courts. It matters whether you transfer under 1404A or 1406A. So everything is the same. Assume that the plaintiffs originally filed suit in state court in California against Piper and Hartzell. We're going to assume that Piper is subject to personal jurisdiction in California. We're going to assume that Hartzell is not subject to personal jurisdiction in California, but it is subject to personal jurisdiction in Pennsylvania. So plaintiffs start out in state court in California. The defendants remove the suit to the federal district court in California, and they then move to transfer venue to the federal district court in Pennsylvania. Now, since there is personal jurisdiction over Piper in California, and everything else is appropriate as to Piper for California, Piper would be moving under 1404A. Since there is no personal jurisdiction over Hartzell in California, Hartzell is moving to transfer under 1406. Of course, Hartzell would also ask that the case be dismissed, but in the alternative, that it should be transferred to Pennsylvania under 1406. Okay, so I'm sorry, this is sort of cut off on the thing. So California is going to be called the transferor court, and Pennsylvania is going to be called the transferee court. And we're going to repeat the substantive tort rules, where the Pennsylvania law is that they recognize strict liability. The Scotland law is that they don't recognize strict liability. California's choice of law rule is the law where the defendant made the product governs. Pennsylvania's choice of law rule is that the law of the place of the accident governs, so those are the same as the last typo. Exactly the same. The state court was going to apply the choice of law rule of its own state, so the California state court will apply the California choice of law rule. Pennsylvania state court would apply the Pennsylvania choice of law rule. Now, the regular federal court, if we didn't have a transfer of venue going on, then a federal district court in California would apply the California choice of law rule, and a federal district court in Pennsylvania would apply the Pennsylvania choice of law rule. That's the same thing we said in the last typo. Now, since we are transferring venue, though, if the transfer occurs under 1404A, then the choice of law rule of the transferor court, which is California, follows the lawsuit with respect to that defendant, the defendant who's moving under 1404A. In this case, that would be Piper. So, in other words, for Piper, the case is now in Pennsylvania Federal District Court. However, since it has been transferred to federal court in Pennsylvania from federal court in California pursuant to 1404A, the Pennsylvania federal court is going to continue to go on and apply the California choice of law rule. And as we said on the last typo, the California choice of law rule is that the law where the defendant made the product governs, and that's of course Pennsylvania. And Pennsylvania's substantive tort rule is that strict liability is recognized. And so we would still be applying Pennsylvania tort law to Piper. The logic behind that is that if you're moving under 1404A, then that means that the plaintiff chose a proper court to begin with. So 1404A assumes that everything is technically correct about the plaintiff's choice of forum. So it would be not fair to change the law on plaintiff by changing the forum, since they chose a proper forum to begin with. So that's why the choice of law rule of the place where the plaintiff originally filed is going to follow this case. However, that same rationale certainly doesn't apply if the forum where the plaintiff originally chose against this defendant was not correct, which with respect to Hartzell, it wasn't, because there was no personal jurisdiction over Hartzell in California. So on a 1406 transfer, the court is not, the California choice of law rule is not going to move with the case. Instead, the transferee court, which is Pennsylvania, is going to go ahead and apply Pennsylvania's choice of law rule. And what was Pennsylvania's choice of law rule? The law of the place of the accident governs. The place of the accident was Scotland, and Scottish tort law is that strict liability is not recognized. So it was something, it probably was not this exact, in fact I'm sure it was not this analysis. I've made this extremely simplified just so that you could get the hang of it. But something like this led the district court in the Piper aircraft case in Pennsylvania to conclude that different laws would apply to Piper and Hartzell, and that one of them would actually probably be subject to Scottish law. All right, so let's get into the Piper aircraft case itself on page 390. Excuse me. So the hypos that I've posed basically tracked the actual facts of Piper. So Reno is the legal representative of the heirs of Scottish passengers who were killed in this plane crash in Scotland. And the plaintiffs go ahead and sue in California State Court. They sue both Piper, the company that manufactured the plane in Pennsylvania, and Hartzell, the company that manufactured the propeller in Ohio. So the defendants remove the case to the Central District of California on the basis of diversity, and then they tell the California District Court, we want to go to Pennsylvania. So Piper moved to transfer under 1404A, and Hartzell actually moved to dismiss on the basis of lack of personal jurisdiction, or in the alternative, to transfer the case to Pennsylvania District Court under 1406. Now, think about what the defendants must have told the court in California when they were wanting to change venue to Pennsylvania. Under 1404A, a change of venue is allowed between federal district courts for the convenience of parties and witnesses in the interest of justice. And so they probably went on about how convenient Pennsylvania was and how all of their witnesses were there and all of the proof relating to the design of the plane was there. And so their motion at that point is Pennsylvania is a great place. Hang on. Okay, so part of 1404A is that it can be transferred to a district, any civil action to any other district where it might have been brought. What does that mean? You look at the transferee forum, which in this case is the Middle District of Pennsylvania, and you ask, is personal jurisdiction proper over the defendants in Pennsylvania? And is venue in this district correct? And so both of those things were appropriate. So the case might have been brought in the Middle District of Pennsylvania. Then, in a brilliant strategic maneuver, once the defendants got to Pennsylvania, they go, oh, Pennsylvania is not convenient at all. Now we want to be in Scotland. So you can't move to transfer a case to Scotland, of course. So the only thing you can do is move to dismiss for forum nonconvenience to allow the case to be refiled in Scotland. And of course, United States law was more favorable to the plaintiffs than Scottish law, which is why they had filed it in the United States to begin with, since Scotland did not allow strict liability and limited damages. So procedurally, what happened before it got to the Supreme Court was that the district court granted the defendant's motion to dismiss for forum nonconvenience, applying the public interest factors and the private interest factors that are quite similar to the ones that we looked at last week with respect to 1404A transfers. And the appellate court, the Third Circuit, reversed the district court's grant of the motion on two grounds. First, that plaintiff's law was going to be worse in the new forum, and so that should prohibit the motion from being granted. And secondly, that even if you look at how the district court applied the public and private interest factors, it abused its discretion, and really the case did not meet the criteria for for dismissing entirely and making the plaintiffs refile in Scotland. All right, so the Supreme Court, minus two justices, gets a majority opinion written by Justice Marshall. And the opinion is fairly clear, but there are places in which it's a little bit disorganized. For example, the outset of the inquiry, which is, you kind of think that would be like at the beginning of the opinion, but no, it's in a footnote toward the end of the opinion. But it says, at the outset of any forum nonconvenience inquiry, the court has to ask, well, is there an alternative forum? You know, if we dismiss here, is the plaintiff really going to be able to go somewhere else and get relief? And that's actually not a very high bar. So basically what it means is that in the alternative suggested forum, in this case, of course, Scotland, that the defendant just be amenable to service of process. And there's just this narrow exception that where a forum will not be considered adequate, where the remedy offered by the other forum is clearly unsatisfactory. So examples of where that has been met are, first, where the court in the alternative forum does not appear to even have subject matter jurisdiction of this kind of dispute. So there wouldn't be any kind of remedy. Or that the law of the foreign country provides no remedy at all for the type of harm suffered. And then in the most extreme case, of course, if the plaintiffs are going to be murdered, if they're relegated to the foreign court, um, that probably isn't a satisfactory forum. Scotland, however, is an acceptable alternative. Even though there's no strict liability, even though the damages are more limited than they would be in the United States, and even though there's no right to jury trial in a civil case in Scotland, it still is a place that generally follows due process of law as we would understand it. So the Supreme Court reverses the Third Circuit and upholds the decision of the District Court to grant the motion for forum nonconvenience. And the first ground that it reverses the Third Circuit on is this whole idea that the Third Circuit said about how if the law in the place to be moved to is worse for the plaintiffs, then you shouldn't grant the motion to dismiss. And the court says, well, no, the fact that the law is going to be worse for the plaintiff in the new forum should not be given conclusive or even substantial weight in the analysis, saying that the whole point of forum nonconvenience is the convenience of the parties and witnesses and the court system, and that we can't have a sort of black letter rule like this because the courts need flexibility to decide what's the best thing to do in a particular case. And then the court said, plaintiffs normally choose to file in the place that will give them the best law. So by definition, if you allow the case to be dismissed and refiled elsewhere, the law is probably always going to be worse for the plaintiffs. And so to have a rule like the Third Circuit's rule would make forum nonconvenience dismissal a rarity. I mean, whether that would be so bad is another question, but that's a normative point that I won't get into right now. Okay, so the second ground for reversal was that it just looked at the public interest and the private interest factors of the Gulf oil case and other precedents. And it said, the district court did not abuse its discretion in applying these factors, as the Third Circuit had held. So the first thing you need to do when you're applying the public and private interest factors and whether the defendants, whether the inconvenience of litigating in the plaintiff's chosen forum to the defendants is so out of proportion to any benefit to the plaintiffs that the motion should be granted. Normally, where you start in this analysis is that you give plaintiffs a strong presumption in favor of their choice of forum. So remember, we're not moving to dismiss because any of these things are wrong, and so the plaintiffs chose a proper forum, and we normally let them choose where they want to sue. So they normally get a strong presumption. And the Supreme Court agreed with the district court in saying, well, yeah, but not where the plaintiffs are foreigners. So we don't want foreign citizens coming over here and using our courts. We're not going to give them a strong presumption in favor of U.S. courts. All right, so first we'll go through the private interest factors, and then we'll go through the public interest factors. So the private interest factors are the ease of access to sources of proof, and in favor of in favor of not granting the motion to dismiss for forum nonconvenience, the plaintiffs were able to point out that, look, all of the records and the witnesses concerning the design, manufacture, and testing of the propellant plane are in the United States, primarily Pennsylvania, so that's where the manufacturer was. And this is a products liability action. So these records are going to be really important to our case. And the court conceded that, but it still thought there was more in Scotland. So looking at witnesses, which is a very important factor, you want to look at two things with regard to the witnesses. First, the availability of compulsory process for attendance of unwilling witnesses. And second, the cost of obtaining attendance for willing witnesses. So in other words, you first look at the witnesses who would not show up to testify at trial if they're not ordered to do so by a court. So does the court have subpoena power to make these witnesses come into court to testify at trial? And the Pennsylvania Federal District Court does not have subpoena power to make any witness in Scotland appear in Pennsylvania if they don't want to. So then you ask, well, but what if they agreed to come to Pennsylvania? So they're willing witnesses, they don't need to be subpoenaed, but you still look at the cost of obtaining their attendance. So of course you need to fly them over here, put them in hotels, etc. So the Supreme Court was impressed by the argument that the witnesses were not subject to compulsory process in the U.S., and the plaintiffs complained that the defendants really didn't provide a whole lot of detail on exactly who those witnesses were that they couldn't get over to Pennsylvania. But the court agreed with the defendants that just suggesting categories of witnesses like the relatives of the decedents was fine. Continuing the private interest factors, one is whether it's feasible or not feasible, but whether it would be advisable to have the jury take a view of the premises, or the finder of fact take a view of the premises. And what does that mean? It's a rarely allowed but potentially available device where a party can ask the judge, if the judge is the fact finder, or ask the judge to allow the jury, if the jury is the fact finder, to go actually take kind of a field trip and go look at, the place where the thing happened. And so the court, it never really came out and said that the fact finder in this case might want to go look at the wreckage of the plane, but it sort of left that idea in your mind as if that would be helpful to anyone. But you might remember, if you're old enough, the O.J. Simpson trial, where the criminal jury in that case was taken down to the house where the murders took place and allowed to look around. So it's called the view. And then there's the catch-all private interest factor, all other practical problems that make trial of a case easy, expeditious, and inexpensive. And the one that the court was impressed with was that if the case proceeded in Pennsylvania, the defendants could not implead possible third-party defendants. So there were all these other possible tortfeasors who were parties to a suit over in the UK, the estate of the pilot, the operator of the plane, the owner of the plane. And so since those people would not be subject to personal jurisdiction in Pennsylvania, the defendant would not be able to file a third-party complaint against those people. Okay, so what's a third-party complaint? We mentioned this with respect to one case that we read this semester, which of course in my current foggy state I can't remember. But anyway, so 14A is the federal rule that allows impleader, and it says the defending party may, as a third-party plaintiff, serve a summons and complaint on a non-party who is or may be liable to it for all or part of the claim against it. So what this allows is, here's the defendant, Piper. If Piper can make some kind of argument under the governing law that if I, Piper, am liable to Reno for, in this case, then you, McDonald, I think that was the operator of the plane, are liable to us for all or part of the damages, because maybe we did design the plane defectively, but you also operated the plane in a negligent manner. And so we were joint tortfeasors. We both contributed to the injury here. And so, if they get all of their damages from us, then you should pay us back some of the damages. So that's the idea of a third-party complaint. Now, if you can't do an impleader, like the court said that Piper and Hartzell could not implead the third-party defendants over in Scotland, or the potential third-party defendants in Scotland, what do you do? Well, what Piper and Hartzell would have to do is, if Reno won the suit against them in Pennsylvania, then it would have to pay Reno, and then it could go over to Scotland and file a contribution suit against McDonald and ask for part or all of the damages from McDonald for, the damages it had to pay to Reno. I remember what case it was now. It was the Asahi case. How could I forget? All right. So those were the private interest factors. And the public interest factors are having the trial in a forum that is at home with the law that governs the action, and avoiding unnecessary problems with conflicts of laws or the application of foreign law. And there's this sort of dread of an American court having to apply foreign law, because it involves experts coming over and testifying about what the law is, etc. And so the Supreme Court recognized that, this choice of law analysis is a very squishy thing. And the district court had decided, based on its choice of law analysis, that American law would apply to Piper and Scottish law would apply to Hartzell. But the Court of Appeals said, no, that's not right. American law is going to apply to both of these defendants. There's no need to apply Scottish law. The Supreme Court did not decide that issue. It just kind of threw up its hands and said, well, it doesn't really matter who's right, because all of the other public interest factors weigh in favor of granting the motion. So the other public interest factors are court congestion, a local interest in having localized controversies decided at home, and the unfairness of burdening citizens in an unrelated forum with jury duty. And it concluded, based on, the fact that it occurred in Scotland and that most of the witnesses were Scottish, that Scotland has a very strong interest in this litigation. So you might say, on the other side of it, well, the defendants here were American companies, so how is this a dispute that is totally Scottish? The plane and the propeller were manufactured in the United States. So it's not really clear that a Pennsylvania jury would in fact have been so upset about hearing the case. But in any event, that was the conclusion of the Supreme Court.